Appeals court rules Kansas Highway Patrol can't target drivers based on state, but two-step questioning remains legal. In a significant ruling with major implications for civil liberties, law enforcement practices, and constitutional protections on America's roadways, the U.S. Court of Appeals for the 10th Circuit has ruled that the Kansas Highway Patrol, KHP, may not target motorists for traffic stops based solely on the state shown on their license plates, a practice that critics said disproportionately affected drivers from states where marijuana is legal. However, the appeals court also reversed part of a lower court's injunction that prohibited the KHP from using its controversial two-step questioning tactic, declaring that the practice is not, under existing precedent, unconstitutional. The decision has placed Kansas at the center of a long-running legal dispute that spans years of litigation, public criticism and debate over law enforcement tactics, interstate travel rights, and the Fourth Amendment's prohibition on unreasonable searches and seizures. Background: what sparked the lawsuit? The legal battle traces back to lawsuits brought by motorists who challenged the Kansas Highway Patrol's practices during traffic stops, particularly along Interstate 70, one of the nation's busiest cross-country corridors. Many motorists, especially those traveling from Colorado and other nearby states where cannabis is legal, alleged that KHP troopers disproportionately stopped and detained out-of-state drivers without reasonable suspicion of wrongdoing. The core allegation was that troopers were making traffic stops not to enforce legitimate traffic laws, but instead to target drivers simply because their license plates were from states perceived to be more likely to have drug contraband. According to critics, this focus on out-of-state plates effectively transformed routine traffic enforcement into a fishing expedition for possible marijuana or other illegal drugs, a practice that many argued lacked any real constitutional basis. The lawsuit gained momentum alongside growing public scrutiny of law enforcement's tactics and the civil liberties implications of extended detentions for motorists who were otherwise compliant and lawful. The Kansas two-step, a central and controversial tactic. One of the most contentious issues in the case was the so-called Kansas two-step, a term critics used to describe a tactic that began as a routine traffic stop but often resulted in additional questioning and extended detention. Here's how the two-step typically worked. 1. A KHP trooper would pull a vehicle over for what appeared to be a minor traffic offense, such as drifting over a line or exceeding the speed limit, and issue a warning or citation. 2. After appearing to conclude the stop, the trooper would take a couple of steps away from the vehicle only to turn around and approach the driver again with additional questions. 3. The trooper would then attempt to gather more information, such as travel plans, intentions, and whether there were illegal drugs, which could then be used to justify calling for a drug-sniffing dog or initiating a more invasive search. Critics argued that the two-step was essentially a pretext to keep drivers detained longer than the original stop required, often without clear reasonable suspicion, and sometimes right at the edge of constitutional protections. The tactic drew widespread attention from civil liberties advocates, including the American Civil Liberties Union, ACLU. Lower court rulings, injunctions and constitutional challenges. In earlier stages of the legal fight, a federal district court agreed with plaintiffs, including motorists like Blaine and Samuel Shaw, Joshua Bozier, Mark Eric, and Shauna Maloney, that the Kansas Lane Patrol was violating constitutional principles. That court granted a permanent injunction against use of the Kansas two-step, finding that it violated motorists' rights under the Fourth Amendment. Judge Catherine H. Vrattel ruled that the Kansas two-step unlawfully detained motorists after the original stop had concluded, and that this extension of detention without reasonable suspicion or probable cause was unconstitutional. Her injunction included requirements such as implementing camera systems in patrol cars, reminding drivers of their right to revoke consent for searches, and additional documentation and training for troopers. 10th Circuit Appeal, Split Ruling. On January 30, 2026, the 10th Circuit addressed two core issues. Targeting drivers based on state is unconstitutional. The appeals court upheld and reinforced the principle that the Kansas Highway Patrol cannot engage in disproportionate stops of drivers based simply on the state their vehicle is registered in, a practice that the court characterized as violating equal protection and Fourth Amendment protections. The 10th Circuit emphasized that law enforcement may not rely on arbitrary factors like state of registration without individualized reasonable suspicion of criminal activity. In its opinion, the court sternly reminded the patrol that focusing on motorists from specific states without individualized suspicion is unconstitutional. We are emphatically reminding KHP that it has been violating the Constitution. That misconduct must end. The ruling effectively ends the practice, at least as a matter of policy, of stopping drivers merely because of where their license plates are from. Two-step questioning is not banned by the appeals court. However, the appeals court took a very different view of the two-step tactic itself. The panel overturned part of the lower court's injunction that prohibited the Kansas two-step, finding that under current Tenth Circuit precedent, the practice is not per se unconstitutional. In other words, the appellate court held that previous decisions in the circuit had upheld or permitted the tactic, and there was no binding authority to support the district court's ban. In light of circuit precedent, we do not think that the record supports injunctive relief regarding the two-step practice of the KHP. This circuit has never held that this practice has violated a driver's constitutional rights and has repeatedly upheld that practice in specific cases. Blaine Franklin Shaw et al. V. Eric Smith. Thus, while the appeals court reinforced prohibitions against discriminatory stops, it rejected the notion that the Kansas two-step, as described in this case, was itself automatically unconstitutional under existing reactions, civil liberties advocates versus law enforcement. The ruling drew strong reactions from both sides of the debate. Civil liberties advocates. Civil rights groups, including the ACLU, criticized the decision to sustain the legality of the two-step, arguing that it allows law enforcement to continue a practice that can function as a covert extension of investigations without proper legal justification. Sharon Brett, legal director for the ACLU of Kansas, has previously described the Kansas two-step as a violation of constitutional rights, asserting that it prolongs traffic stops unnecessarily and creates situations where motorists feel compelled to answer more questions or consent to a search. Critics argue that many drivers do not know they have the right to decline further questioning or understand when a stop has officially concluded, making the two-step a potentially coercive tactic in practice. Law enforcement and supporters. Supporters of the appeals court's decision, including law enforcement officials and some legal analysts, welcomed aspects of the ruling, particularly the affirmation that established circuit precedent remains intact regarding the two-step practice. For them, the decision preserves law enforcement tools used in drug interdiction and investigation, albeit with constitutional limitations on discriminatory stops. Proponents argue that training and proper application can allow officers to use additional questioning tactically without violating motorists' constitutional rights, provided that the stop does not unjustifiably extend beyond its original purpose. Broader legal and societal implications. The appeals court ruling carries important implications beyond Kansas. Our interstate travel rights. The decision reinforces the principle that motorists traveling through states where certain activities are legal, such as marijuana use, retain full constitutional protections and cannot be singled out based on assumptions about legality or risk. A Fourth Amendment enforcement. By striking down state-based targeting while leaving the two-step intact, the court drew a nuanced line between discriminatory policing and broader investigative techniques, a line that may be tested in future cases. A law enforcement policy reform. Agencies across the country may revisit their training and traffic stop policies to ensure they are not relying on impermissible factors like license plate origin. Many departments could see this as a prompt to refine how consent and voluntary questioning are explained to motorists. A public awareness of rights. The case highlights a critical need for drivers to understand their constitutional rights during traffic stops, including when they are free to go and how consent for searches works, knowledge that is still uncommon among the general public. Conclusion. The Tenth Circuit's ruling in Shaw et al. V. Kansas Highway Patrol marks a watershed moment in the ongoing national conversation about civil liberties, law enforcement authority, and the limitations of investigative techniques on America's highways. By declaring that targeting drivers based on the state of their license plates is unconstitutional, the appeals court reaffirmed long-standing protections against arbitrary policing. However, by stopping short of banning the controversial two-step technique, the court also underscored the complexity of balancing law enforcement interests with constitutional safeguards. The case leaves open important questions about how police engage with motorists, how courts interpret consent and detention, and what standards should govern the delicate intersection between highway safety and civil rights, questions that will likely continue to be litigated for years to come.